The effort to strike down California's ban on the purchase and possession of suppressors is now in front of the Ninth Circuit. This is a critical challenge that could open the door for suppressors to finally be owned and used in California. So let's break down what is happening in this critical case. Now, before we jump into this video, I actually just want to bring awareness to CRPA. CRPA is the ones who have now jumped into this lawsuit and are helping the plaintiff here to litigate this in front of the Ninth Circuit. So right now they're doing donations for this lawsuit and other suppressor challenges. I will leave a link to that down below in the detail section in the pinned comment. They didn't ask me to do this, but if you use that link and donate to them, of course it'll help this lawsuit and help us all here in California and other states to get rid of these suppressor bans. Like I mentioned in the intro, in this video, we're going to be breaking down a critical challenge that aims to strike down California's ban on the purchase and possession of suppressors. The case we're going to be talking about in this video is called Sanchez versus Bonta, which is currently in front of the Ninth Circuit Court of Appeals. This case started with the plaintiff here, Mr. Sanchez, representing himself pro se, so essentially he didn't have an attorney, he did this on his own. But now with this challenge in front of the Ninth Circuit, California Rifle and Pistol Association, CRPA, along with the attorneys over at Cooper & Kirk and Michelle & Associates, have stepped in to represent him against the state of California. This challenge, if successful, would obviously be significant, not just for the state of California, to allow, just traditional residents to have suppressors, but also this could lead to strong precedent in other jurisdictions and also set up a very critical circuit split, so this could finally make its way to the Supreme Court. Now, this lawsuit, as I mentioned, was filed pro se by Mr. Sanchez, and this sets up a critical question of whether suppressors are arms and therefore subject to the history and tradition analysis which was established by the Supreme Court in New York State Rifle and Pistol Association versus Bruin. Now, the facts around this case are that Mr. Sanchez started this lawsuit because he wanted to create a 3D printed suppressor. So he applied for his federal forms to the ATF as required by the NFA, but he was denied because suppressors are clearly illegal in California. So we have California state laws which prohibit that type of action. And as a result of that denial, he filed a facial challenge against California Penal Code 33410. This section of California law provides that possession of a silencer is in fact a felony offense. So the California law states that any person, firm, or corporation who within the state possesses a silencer is guilty of a felony, and upon conviction thereof shall be punished by imprisonment pursuant to subdivision H of section 1170, or by a fine not to exceed $10,000, or both, that a fine and imprisonment. He alleged that this statute in California on its face violates the Second Amendment of the United States Constitution. The complaint sought a judicial declaration from the court that this section of California law is unconstitutional on its face, as well as he wanted an injunction to essentially prevent California from enforcing this law in its entirety against just him, as well as everyone else in California. Now, on June 24th, 2024, California moved in this lawsuit in the lower court to dismiss the complaint for a failure to state a claim. California alleged that the lawsuit was invalid and should be thrown out early because suppressors, in their eyes, are not arms protected by the Second Amendment. And because of that, Mr. Sanchez's Second Amendment claims, they argued, must also be thrown out. Now, on review, the district court Judge Robert Hugh agreed with California, finding that suppressors are not arms and therefore not protected. He then issued the motion to dismiss in favor of the state of California. So in his decision, the judge stated that the plain text of the Second Amendment covers the right to keep and bear arms. Heller observed that the 18th century meaning of arms is no different from the meaning of today, and offered two 18th century definitions, which were weapons of offense or armor of defense, and anything that a man wears for his defense or takes into his hands to use in wrath to cast at or strike another. The court stated that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. But then in his decision, he went on to find that numerous courts have held that post-Bruin, silencers are not arms protected by the Second Amendment. The court is not aware of any court reaching the opposite conclusion. The court agrees with the conclusion and reasoning of the cases cited above, and he cites here to a bunch of other circuit courts like the 10th Circuit that found that suppressors are not protected. He goes on to state that a silencer is neither a weapon in itself nor a defensive armor. As plaintiff concedes, it is an accessory, nor does plaintiff dispute that unlike ammunition, a silencer is an accessory unnecessary to the essential operation of a firearm. However desirable the silencer may be to a user in reducing noise, flash, or recoil, or in allowing the user to stay hidden while firing. He then cited to the 10th Circuit Cox decision, which actually rejected arguments that silencers merit Second Amendment protection because they protect the shooter's hearing, reduce muzzle flinch and disorientation, enhance shooting accuracy, and save time in a defensive situation. Silencers are nonetheless accessories rather than bearable arms. So the court concludes here that silencers are not bearable arms for the purpose of the Second Amendment, and accordingly, they found that the plaintiff's facial constitutional challenge against Section 33410 fails to state a claim. Now, if this rationale of the district court sounds familiar, that's because it's very similar to what we just saw the Peterson Fifth Circuit decision actually issue on suppressors. And also, these are the same type of arguments that states like Illinois are making in their suppressor lawsuits in the Morse versus Raoul case. There has been one consistent thread with most courts who have reviewed this issue. Almost all of them have claimed that suppressors are not protected arms, and at best, they're simply accessories, but also they find that they are not necessary for the operation of a firearm. The judge in this case found that Mr. Sanchez would not even be given the option to actually leave to amend his complaint because the judge believed that the Second Amendment arguments were so deficient and they could not be cured. Now, as a result of that ruling, Mr. Sanchez then appealed up to the Ninth Circuit. Originally, when he appealed, he sought a preliminary injunction from the Ninth Circuit, from the motions panel, and he wanted the preliminary injunction pending appeal. That motion went to the motions panel, but was rejected by the motions panel in the Ninth Circuit. Now, I do want to say that as a pro se litigant, Mr. Sanchez did a great job preserving some of the facial challenges and kind of following the correct procedures to advance this challenge to the Ninth Circuit. Now, after that, the case was then fully briefed and completed by February 3rd. And so again, this was in front of the Ninth Circuit. But then the Ninth Circuit did something really interesting. They issued an order stating that they would be interested in appointing counsel to Mr. Sanchez so that he could fully brief this appropriately and kind of have the best shot to advance his case. This, of course, was surprising since the Ninth Circuit could have just simply taken the easy way out and ruled against the pro se litigant on appeal, but instead they are allowing kind of the best case to be presented and allowing Mr. Sanchez to get the best representation. Now, as a result of that order, California Rifle and Pistol Association, CRPA, and the law firm of Cooper & Kirk and Michelle & Associates will be joining Mr. Sanchez as his legal team and will represent him on appeal in the Ninth Circuit. Obviously, CRPA, Cooper & Kirk, Michelle & Associates, all of them are very familiar with the Ninth Circuit and all of these two-way issues, and it will give Mr. Sanchez the best opportunity to present his best case on appeal. Now, what will happen from here is there will be new briefings scheduled probably by the Ninth Circuit, and then once that's completed, the Ninth Circuit will schedule and hold oral arguments on this issue. Now, like I mentioned, this case is now kind of in its best chance and its best opportunity to fight and potentially strike down suppressor bans in California. However, keep in mind, this is still the Ninth Circuit who has upheld magazine and rifle bans in the past. They tend to not be pro 2A. There have been some decisions in the Ninth Circuit that have been pro 2A, at least at a 3-judge panel level in the Ninth Circuit. The en banc panel has not been super favorable. So it's kind of been a little bit better than it was in the past with some of the Trump judge appointees, but still it's the Ninth Circuit. And we've seen, especially recently with the en banc panel in the Ninth Circuit, they've reviewed cases like the Duncan magazine ban, and they heard oral arguments, and it's been almost about a year since they've issued the decision. They've just been sitting on that, have not issued a decision. So it's been a hard time even getting the Ninth Circuit to rule on protections for magazines, and so it's probably going to be even harder to get them to rule in favor of protections for suppressors. But this, of course, is an important case that we're going to be watching going forward. Selfishly, as someone who's in California as a resident and lives under these insane California gun laws, of course, I will be praying for a win in this case. Again, I highly recommend you go support CRPA and donate to them for this effort and the fundraising for this lawsuit. Again, links will be down below in the detail section in the pinned comment. Please share this video around to every gun owner you know in California and others in potentially other states who live under suppressor bans. We would love to get a win in this case and potentially also set up a circuit split in the hopes to eventually get a challenge like this in front of the Supreme Court. Because right now you have a ton of other circuit courts like the 10th Circuit, 5th Circuit, and others who have ruled that suppressors are not protected. So again, we need a circuit split to potentially elevate this to the Supreme Court and get them interested in this type of issue. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.